And the combination of indicators for each situation are analyzed in order to determine whether the situation is one of forced labor or not. So we need to remember, in the first case, that this involves all types of work, service, employment, regardless of the industry, the sector, the occupation within which it's found. And it encompasses legal and formal employment, as well as illegal and informal work. Factor 2 refers to all people. So children, adults, male, female, regardless of age, all people are involved. The third factor refers to a worker believing that he or she will face a penalty if they refuse to do the work. And then finally, this refers to worker consent to enter into employment and their freedom to leave the employment at any time with reasonable notice in accordance with national law or collective agreements if they're in place. So all of those elements have to be in place before we have a situation where we have a forced labor dynamic. Each one is analyzed. Sometimes they're combined. Sometimes they can stand alone to indicate forced labor is being used. So where is it? As I mentioned in my introduction, there are 77 countries that have been identified by the U.S. Department of Labor where forced labor is being used. So here is a chart that represents a breakdown within broader product sector categories. You must keep in mind that just one thread of clothing can make the finished wearing apparel product one of forced labor, and therefore it could be subject to detention, possible exclusion, possible criminal investigation, and possible penalties. You'll see here there's a broad range of agricultural products and those that are mined, but you can also see garments, textiles, and footwear. I apologize, I could not change the footwear typo there because this is embedded in a chart that the U.S. Department of Labor's Bureau of International Labor Affairs publishes. So they're on the list as well. So now, what's the most current forced labor enforcement? So I mentioned that we've got the cotton and tomatoes grown in the Jiang province of China. The most current issue facing importers of wearing apparel obviously involves the cotton grown and harvested in the Jiang province of China. Now, we know that in July 2020, CBP put this issue on everybody's radar screen. It gave importers 6 months to review their supply chains, change sourcing strategies if necessary, and ensure that they had systems in place to address a potential issue. And basically, that really is the ability to access the appropriate documents for customs. In January 2021, as I mentioned, CBP published the withhold release order and began their enforcement. And this WRO is the one with the greatest impact on wearing apparel and textile products. As you can see, there are 34 active WROs affecting Chinese origin goods. We've got stevia, toys, etc. And then we've got the newest WRO for Top Glove, the manufacturer in Malaysia, but also for Malaysia, we have palm oil. Now you can go either on the Department of Labor's website or on CBP's website, and you can see a list of all both active and inactive WROs or issues involving products and countries on the Department of Labor list. And I highly recommend that you really review these lists, have your social compliance departments review these lists on a daily basis. Now, how is the forced labor law enforced? I will discuss some current enforcement issues that I've been tracking with clients. Over the last 2 weeks, I have been in discussion with Customs and Border Protection at the headquarters policy level and also at the Center for Excellence and Expertise. So I want to share some of the things that they've shared with me. So remember, even if you do not source directly from a country listed as using forced labor, you can still be in violation of the law if a third party sources from that country. So if they're on the Department of Labor list or subject to a CBP WRO, that could happen. So for example, if your wearing apparel manufacturer is located in Bangladesh, and this is a real situation that I dealt with, but obtains cotton fabric that was made from cotton harvested in the Jiang region of China, your assembled final product is subject to the WRO. So it does not matter what the country of origin is that you declare to customs. What matters is the inherent component part of the wearing apparel. So the bottom line is that you need to know how your finished product, that product that you want to sell in US markets, how that product was manufactured. What components went into the product? What was the source of those component parts? Whoever is producing the finished product needs to be asking these questions and also maintaining the documents that support the answers, and they need to drill down into your supply chain. So what is this consumptive demand clause that I mentioned up front when I talked about the current challenges? What the consumptive demand clause provided for in the original legislation back in 1930 was that if you had a domestic industry in the United States that could not produce enough product to meet the domestic demand for consuming the goods, then products made with forced labor could come into the United States. This part of the 1930 law, which allowed a loophole basically, was eliminated with the passage of the Trade Facilitation and Trade Enforcement Act of 2016. So the bottom line is no products made with forced labor can enter the United States. It's important to really understand the steps that Customs and Border Protection will take when dealing with potential forced labor violations. Now, you can see at the very beginning of this chart, the receipt of an allegation. This can come from anywhere. It can come from the trade. It can come from non-government organizations. It could come from a foreign government. And the agency, CBP, can self-initiate the enforcement process. But for importers, the key areas of concern will be the withhold release order and subsequent steps. The goods may not be released into the commerce of the United States once you have a withhold release order until CBP is satisfied that the affected shipment is not made in whole or in part by forced labor. Now, after the WRO is issued, the goods are going to be detained for the most part. Now, we said with Top Glove, the goods are being seized outright. But for the Jiang cotton, they are being detained. This detention process can last for months because CBP is going to initiate their investigation of the matter. And now the agency is definitely going to disagree with me when I say the program results in you are guilty until proven innocent. The agency is going to say that importers have due process, that there are 4 key options when your goods are caught up in a WRO enforcement action. So number one, you can export the goods out of the United States, either back to the country of origin, or if you find a buyer in another country. Second, you can provide and produce evidence that will show that the finished products and the constituent components were not made using forced labor. If you wind up in a situation where the goods are excluded, whether customs they are deemed excluded, meaning the clock has run, or customs takes the action to exclude them, then you may protest that exclusion under 19 USC 1514. If your protest is rejected, then finally you can take the matter to court and have a judicial decision. So let's look at some of these issues. Now, in my recent discussions with CBP, they have raised the overall concern of commingling of cotton from Xi'an with other cotton sourced outside of China that's not currently subject to the WRO. So you may be using cotton from another country, but you may be producing the final product in China, and customs is concerned that the fibers are being commingled. Okay, so that's the one issue, and they say it is the highest risk for them. CBP has also asked for extensive documentation and have said to me, yeah, do not throw the kitchen sink at us, okay, without a roadmap. CBP is coming at your documents cold, and you need to present the documents in a logical progression of manufacture through the supply chain with a descriptive index that will guide them through your documentary information package. So obviously you're going to provide your purchase orders, whether for the final product or the purchase order of components, payment records, transportation documents. Now, what was very interesting, and affidavits is very important, but what was very interesting is one of my clients provided the names in the supply chain of Chinese companies in Chinese characters. And customs pushed back and said, we want those characters plus their translation into English. So what happens when you decide, after receiving a detention under the WRO process, when you decide you're going to provide documentary evidence to customs to show that forced labor was not used in your supply chain? Those documents are received by CBP and they're subject to review by an import specialist assigned to the CEE. Now, you may be importing through the Port of Newark, you may be importing through Los Angeles, Long Beach, and your import specialist assigned to your documents could be sitting in Laredo, Texas. Remember, these are virtual teams and anyone can get assigned your situation. Additional questions may be asked, or additional documents may be required, or they may not ask anything from you. Once the import specialist review is completed, which normally takes anywhere from 3 to 5 weeks, it goes into additional reviews. So it may go to the Office of Chief Counsel in Customs Headquarters, and it could go to the Forced Labor Office and Headquarters. So you may have a series of additional reviews that are very time consuming. Customs has said to me, quote, it is a highly bureaucratic process. And what I've seen is that the agency has been slow to communicate the outcome of reviews. As a result, shipments have been hitting the 90-day mark and have been deemed excluded. So as I mentioned a few minutes ago, a deemed exclusion occurs when the clock runs and CBP has not taken any definitive action. And once the entry is deemed excluded, you have 60 days to export or you can protest the exclusion. And again, what happens is very often the import specialist that has reviewed your initial package may also be the same import specialist reviewing your protest. Let's look at two scenarios I've been dealing with recently. One is we have organic cotton, which is grown, harvested, and ginned in India. The cotton is then shipped to a yarn spinner located in China. The spun yarn is shipped to a fabric maker in China. And then finally, the fabric is shipped to the final cut and sew assembly manufacturer in China. Now, in this instance, the importer has a very, very tight supply chain. They nominate all participating companies in the supply chain, and CBP allowed these goods to deem exclude. CBP raised concerns about commingling of Chinese cotton with the Indian organic cotton at the yarn spinner level. Now, the cotton was certified under the Global Organic Textile Standard Certification Program, so GOTS. All the Chinese companies in the supply chain are part of the Fair Labor Association Standards Program. GOTS certified the cotton, but customs would not release them out of detention, and they went into deemed exclusion. The importer, my client, is now protesting that deemed exclusion. In the second scenario, we have cotton grown, harvested, ginned, and spun in India. And then the spun yarn is shipped from India to a fabric maker in China. The fabric is then shipped to that final cut and sew assembler in China. Now, in this case, customs released these shipments. The only difference between scenario 1 and scenario 2 is that the yarn was spun outside of China in scenario 1. It appears that once the yarn is spun, that the product doesn't contain cotton from other countries, meaning the spun cotton from India cannot incorporate Chinese commingled cotton into the product. Now, in a number of instances, also, CBP has stated that they are targeting the manufacturer, and yet in the first scenario, they released all non-cotton goods. And this is the argument that I made with CBP. If you were concerned about the manufacturer, why, as having forced labor in their employee group, why would you release the non-cotton goods? And obviously, in addition, the current WRO targets cotton grown in Jiang province. So that's a little bit of an interesting dynamic. So let's look at what customs says about commingling. We had a discussion about 2 weeks ago on this. So how do you address commingling? First thing that customs asked my client, and I had a discussion with them on this, is, did you do any scientific analysis? CBP will look at what you have done to scientifically analyze the origin of the cotton in the final product. While CBP normally does not accept the results of a third-party lab testing, in this case, CBP has stated that they will consider any scientific analysis performed and provided in the document submission. Now, normally, if CBP tests a product and you have an outside lab do a test, CBP's results always trump the third-party lab results. But in this case, even if CBP does analysis, they will work with you to look at your results. The other thing that they have suggested, which to me is darn near impossible, is direct identification. And obviously, direct identification is literally a process to track the growth of the cotton, the harvesting of the cotton, take that through to the ginning, the spinning, the weaving, and you must ensure that the cotton harvested and baled is what exactly is contained in your final garment. What was grown and what went into the final product must be exact and must be traceable. CBP, as I said, recognizes that this is extremely difficult to do. So you have to determine, when we're talking about commingling and how your process, your manufacturing process and your supply chain process is working, you have to determine if that supply chain is capable of being breached at any point. So, as I previously mentioned, CBP is letting the clock tick. Once this happens, the goods move from detention to exclusion, and you have those 60 days to export the goods, or you can file the protest. As I said, the protest is very often reviewed by the same person who reviewed the documentary evidence to begin with. Now, you can request a further review of the protest by an attorney in Customs Office of Regulations and Rulings. But the external lawyers, company lawyers that I've talked to, really don't recommend asking for further review. It adds more time to the clock, and often the OR&R attorney will wind up agreeing with the initial review that took place by the import specialist in the CEE. CBP has indicated if a company, once they get a detention, if they upfront decide to export the goods and not attempt to answer the request for information in that detention notice, that company will not become a high-risk target for the future. Okay? You have to make a business decision, and Customs realizes that. Why is this an issue for you? Why is forced labor a problem? Well, obviously, the most important thing is to get goods on the shelves. One of my clients has anywhere from 15 to 20% of their inventory caught in detention right now. They cannot make money if they cannot sell product. So if your goods are caught up in detentions and exclusions, obviously the financial burden on your company could potentially be crushing. In the case of Top Glove, we've got loss of merchandise through actual seizure. There's monetary penalties that could be issued to the company. If CBP believes the violation is egregious enough, they can refer the violation to Homeland Security Investigations, ICE. And whenever ICE accepts an investigation, it is always a criminal investigation. And obviously, criminal investigations can result in criminal prosecution. Business relationships are ruined, and finally, there's a damage to the corporate brand. We know we have very savvy consumers that are not going to accept product that is, in fact, using forced labor. So now, what do you do to protect your business? How do you handle some of these issues? I would say it's better to be in an offensive position as opposed to a defensive position. With forced labor, always remember that the burden of proof rests with the importer. Customs has told me they do not have to prove that forced labor is involved in the production of the goods, but the importer must prove that forced labor was not involved in the manufacture of the goods being entered into the United States. So recommendations, obviously, engage in verification of product supply chains to evaluate and address risks for forced or child labor. Conduct an independent audit of suppliers. Now, it's my understanding that Customs is not too enthusiastic about these third-party audits. So if you're going to do this, be careful of how you choose a company. Try to partner with somebody that has a tried and true and tested program, maybe with other companies, maybe with various associations, but be very, very careful who you choose. Require direct suppliers in your supply chain to certify that materials incorporated into the product comply with forced labor laws for the countries in which they are doing business. Maintain accountability standards and procedures for employees or contractors that fail to meet company standards. Recently, I heard Customs say that if in fact a U.S. importer finds that there's a forced labor dynamic in their supply chain, they should remediate that issue. Now, I'm not sure how easy that is for somebody to go and try to correct a forced labor issue. One of the things that I think Customs is looking very positively on is providing employees and management training on forced labor issues and trying to drill down through the supply chain and provide that training throughout the supply chain. Engage in due diligence to include policy, risk assessments, monitoring, auditing, and again, remediation. This due diligence should include completing a self-assessment of supplier compliance with forced labor laws. And the thing is, you need to move beyond the first-tier vendors in an attempt to ensure a socially responsible supply chain free of forced labor. And, you know, obviously with the Zhang cotton, you're going all the way back to the growth of the cotton in the field. With Top Glove, you're at the manufacturer level only. You don't have to go back and look at, you know, the component parts. It is at the assembly. So you're on either end of the spectrum. And what you need to do is really understand what the WRO is, what the scope is, and how it fits into your supply chain. So review that WRO with your broker, with in-house counsel, with external counsel, to determine how does it affect my supply chain. Then test those entry transactions to see what documents can be obtained. Are they sufficient? Do they make sense in the manufacturing timeline? I had another client call me yesterday, and as of last Friday, they were going to provide documentary evidence to Customs that forced labor was not in their chain. Well, yesterday they said, well, we thought over the weekend we were going to get documents, and we did not. So we realized we have an inadequate package. Should we submit it to Customs? And I responded, no. If you know that your package, that your documents are insufficient, do not give them to Customs. Make sure you have a comfort level with the documents, that you've really crossed every T and dotted every I before you submit them. So we made a decision that the goods should be exported. So partner with other companies, associations, and internationally accepted certification programs. But again, one client partnered with GOTS, partnered with the Fair Labor Association, and still could not get their goods released. I highly recommend having a corporate strategic plan in place in the event that you have a potential WRO detention. Don't think it won't happen to you. And again, better to be ready with an offensive strategy than to be on the defensive and be trying to figure out at the last minute what you're going to do. You have to decide what's in the best interest of your company. When we talked about the scenario 1 and the scenario 2, we saw that in the first scenario, they were spinning cotton in China, Scenario 2, they were spinning the cotton in India, and that made all the difference. So you may look at your supply chain across the board within your strategic plan and say, well, maybe I just need to do a minor tweaking of how my goods are manufactured. You have to decide what's in the best interest, as I said, of your company. What do you know about the complete supply chain? You must get a solid understanding of the chain depending upon what area of the chain the WRO affects. And again, with Zhang Cotton, it's at the field, and in other instances, it could be at the manufacturer, or maybe it's the spinner, okay? If you are talking about top gloves, like we said, it's at the factory level. So depending on how comfortable you are with the supply chain, that comfort level should drive your approach. So perform a cost-benefit analysis to assist in your decision-making. Do I keep the goods and then provide the documents? Do I export the goods? Do I have the ability to obtain the requisite documents that customs is looking for? Do I just do a minor shift in the supply chain, or do I have to do a major shift in my country of origin? Am I able to develop alternative selling markets? Now, in one case, one of my clients said, look, I'm a domestic seller. I just sell in the US. And somebody else said, no, we have retail stores all over the world. We're going to export, and we'll put those goods on the shelf in other countries. I'm also going to say, with this entire situation, going back to my own customs experience, that be aware of illegal transshipment and the use of counterfeit documents by companies in the supply chain. I would work closely with your custom house broker to ensure swift action once you make a decision. Do you need to export the goods? We had one client that had all their goods stored in an air carrier's premises, and in a few short weeks, they had $250,000 worth of storage fees at the carrier. So what do I have? Can I get those goods moved to a warehouse where my charges for storage are much, less, and have a less of an impact, a financial impact on my company? And I think that's the important thing to do. You need to really do what I would call a decision-making matrix. If this happens, what should I do? If that happens, what should I do? And I think just, really being prepared up front is going to help you in the long run. So now, if we look at this is a business tool for labor compliance, and it's the U.S. Department of Labor. And they define the steps to a social compliance system. So there's 8 steps here. You can read those, but what they're suggesting really is that you prepare a comprehensive supply chain profile. So do you have a comprehensive understanding of the natural supply chain, from sourcing of raw materials to subcontracting manufacturing to the assembly of the finished goods destined for the U.S.? For your products, has the U.S. importer conducted a comprehensive risk assessment in the global supply chain and conducted on-site production visits to factories, farms, mines, or whatever it is in the high-risk country? Is the U.S. importer engaged with industry-specific multi-stakeholder initiatives? Again, I'm sure most of you have written codes of conduct with your suppliers and your manufacturers overseas, but have you developed and applied a formal written code of conduct for all international transactions associated with the sourcing of foreign goods as it relates to forced labor? Do you share that code of conduct through your entire supply chain, not just your first-tier vendor? Is it shared as an addendum or a standalone document to purchase orders, contracts, or letters of credit? And then finally, do you have in your company robust internal control procedures so that, in fact, you are not negatively impacted by a potential forced labor action. So are the internal controls established according to professionally recognized objective audit standards? Do you have sufficient internal controls in place to effectively deter and detect instances of noncompliance and also to correct instances of noncompliance? Do you perform periodic compliance audits, either using your in-house personnel or external audit professionals? Do you have internal controls that cover every level of the product supply chain? And then finally, again, do you correct? Do you have training in place to be able to ensure that you're protected? I would highly recommend the Department of Labor's app called Comply Chain that helps and walks you through many procedures that you can take and also really keeps you up to date on what's happening with this issue. So in conclusion, in my discussions with CBP, they really consider forced labor a pervasive, a broad, and global problem. They'll be the first to tell you that they do not have the requisite resources to address all the violations. And I've had one client, for example, that had a number of products released, and they were like, wow, I dodged a bullet. And then a few days later, they wound up getting a redelivery notice, and you don't want that. CBP is really relying on the trade to self-enforce, to do their part. And finally, again, remember the process is extremely cumbersome and bureaucratic. So from my perspective, it's best to be ready and to be prepared. So I've gone on for 45 minutes here, and I want to thank you very much for joining me today. And I'll send this over back to Shannon so we can open up the chat box for comments or questions. And thank you very much.
Thank you so much, Janet, for all of the wonderful information you provided today. As Janet mentioned, we are going to turn the floor over to our audience now. We'll begin with questions submitted during the live presentation, but we encourage you to continue submitting questions using your dashboard. So our first question is asking about a scenario where there are goods made in Bangladesh with Chinese fabric, and it's asking, what should you do in the 95% likelihood that you cannot confirm the route back to the field, especially with commingling concerns?
Okay, I will reiterate what I said, and I would highly recommend that you try to get some scientific analysis, and again, be very careful who you choose in doing that. And if you can't go back to the field and you can't show that there was no commingling, I would highly recommend that if, in fact, you have not shipped the goods, that you do not ship the goods, number one. If you have a WRO and you have a detention and you believe you cannot go back to that field, I would export the merchandise. Customs is taking a very hard line on these issues.
Great, thank you. And our next question, what is the status of goods that are exported prior to exclusion?
Well, if you haven't gone into exclusion, you could at any point before exclusion just export the goods. I mean, that's the bottom line, and it will not adversely impact or affect your relationship with CBP, and you will not be, basically targeted in subsequent shipments. Unless, it's not going to be, you're not going to be targeted. It's just going to be that either the manufacturer that you use or the product that you're bringing in can be targeted. But, I think you have to make what I would call a prudent decision at the end of the day. Do you want to hang on to these goods and pay legal fees and pay storage fees and go through the expense of obtaining documents and having somebody organize those documents and present them to customs, and then wait maybe, 4 months or 5 months before the goods potentially are released. These are the decisions that you really have to look at in relation to your whole business structure, your business model.
Great, thank you. And our next question is asking if you have an idea of the current success rate of protests filed after exclusion.
I think we're too early in the process. I don't think there's that many protests yet, because I think the clock is still running in certain areas. Customs, gives their normal 30 days to respond to a detention, but in fact, they're really giving 90 days. And so, then they realize they're taking another 3 to 5 weeks to do the first level review with the import specialist at the CEE. And then that product, that package has to go to, chief counsel and other offices and headquarters for review. So some of the clients that I'm dealing with are just now at the stage where they are submitting protests. And then obviously customs has a certain amount of time to review the protests. So they're looking at the documentation that you provided for the detention. That's taking time. And then they're looking at the documentation. And normally when you have a protest, it's like you have to provide new information. Something new came up that wasn't in the original documentary package that you submitted. So, it's like asking for a retrial in a criminal prosecution where you found, new evidence showed, and you present this to customs. So if we're too soon in the process, I spoke to customs 2 weeks ago and they said, look, some people are, quote, are going to win some protests and some people are going to lose some protests. So we're just not there yet.
Great, thank you so much. Our next question, are there statistics on the percent of products being imported from China that are being detained or rejected by CBP for forced labor issues?
Well, I just do know that right now, Customs recently just did a publication of some of their trade statistics. And as I said, it's about 300 detentions that are worth about $20 million. They normally do not update those statistics except on a quarterly basis. And we've had some major changes in customs recently. We've had some changes at for example, the executive assistant commissioner for the Office of Trade. So there are a number of dynamics occurring in the organization. And every time you have a new administration, there's a lot of focus on preparing the new administration and the new commissioner and things like that. So they sometimes get sidetracked and they may not update those numbers for 6 months. So we can only rely on their numbers. They're the only ones that know what they've detained, what they've excluded, et cetera.
Great, thank you very much. And our next couple questions are based on scenarios. So what if you discover forced labor was used for a shipment that was entered, released, and sold in February 2021, for example?
Keep quiet. No, I think that that's a hard question to ask. I think you would have to sit with your attorneys in-house, maybe external attorneys, to decide what to do. It's very, very difficult. I would say that if in fact you found something like that, the first thing that I would do is go back and try to remediate through the supply chain so that it doesn't happen again. I mean, things are going to happen. Customs is going to miss things. You're going to miss some things. I know normally somebody might say, oh yeah, do a prior disclosure and tell customs what happened. But I can't answer that at this point. I think this is a technical, complex legal issue that you're best to discuss with a good, solid trade attorney that maybe has had experience with some other clients on these issues. But again, Customs is looking at, if you find an issue and you're able to remediate that issue wherever it is in the supply chain, then you would take those steps. But as far as what you would do in relation to communicating with Customs, again, I would say the best thing to do is talk to your attorney.
Great, thank you very much. And our next question, so if you receive a WRO and export those goods, won't that MID be targeted on future shipments?
I mean, it potentially, obviously could, because it depends on the situation, because even with the Zhang cotton, now the WRO targets the product, targets cotton, okay? And yet Customs tells me we're targeting the manufacturer, okay? So again, you need to, as I said, look at the scope, and also if in fact you export, but you know, and this has happened to one of my clients, that you have, hey, I've got 10 more shipments coming in. One is already on the high seas. 3 are getting ready to ship, 4 are in production. You have to make a decision, and rightly so. Customs probably will target the manufacturer. They're not going to target you per se. They're not going to say, oh, okay, it's company X, we're going to go after them. No, it's manufacturer X that they're going to target. So yes, they could very easily target the next, that MID and the next shipments and the ones that are on the high seas, et cetera. And the other thing, please be very, very aware of, is make sure your MID is correct. We had one situation where the MID was incorrect, and that could affect, now you're in a forced labor targeting situation when you should not have been in a forced labor targeting situation.
Great, thank you. So our next question is asking, what types of controls have you seen or supplied to CBP around the cotton ginner portion of the supply chain?
I haven't personally seen anything at that level per se. I just know, for example, that in the one instance where the cotton was organic, being grown in India, the GOTS certification program certified it through the process. So you've got that certification, and what is also important is affidavits at those levels. So with GOTS, they're kind of certifying that this organic cotton is going through the process, and it's basically supposed to show that no commingling has occurred. But yet, I guess once it hit the spinner level, everything fell apart there, so to speak. So that's the only thing that I have seen that you could show that, the product was transported, to this place and went and was in this bale and came out in this bale and so on and so forth. But much of that is really internationally accepted third-party certification.
Thank you. And kind of to piggyback off of that question, what kinds of scientific analysis are out there, and what technologies does CBP consider acceptable for identifying the origin of cotton?
Well, obviously I am not in a position to really recommend a company. The only company that I have been in discussion with last week is a company called Oratane. They're based in New Zealand. They have offices in London, and I had discussions with their London office. I know they're going to be having, I believe, establishing an office in Washington, D.C., and they do isotope analysis, scientific analysis, and they do forensics, obviously. And what they presented was extremely interesting, because what they showed through the isotopes is they're even able to get back to the actual field where the cotton was grown. So it's not just the country of origin, but the field. And I found that, very, very interesting. And to my understanding, they have been in discussions with CBP. So CBP has various types of analysis as well. They have very extensive state-of-the-art labs around the country, but obviously you can't ask them to on your behalf analyze your product. So I would look at that. The other thing I would look at is any companies that might give you better clarification and insight into the supply chain. Who owns whom in that supply chain, what companies are involved, and are any of these companies being targeted or looked at for forced labor issues.
Thank you. And we have a few more questions before we wrap up today. The next one is CBP open to partnering with the trade on this issue, particularly transparency and information shared between CBP and the trade in order to work in concert to fight forced labor? If so, how should we start that dialogue with CBP?
Well, one of the clients that I had was not a known client to CBP. And I was able to get CBP to entertain a discussion with them where they were able to discuss their entire supply chain, the fact that it was a very tight supply chain, that in fact they nominated everyone in the supply chain and that they were GOT certified. And I even know that Elise Scheibels, who used to work for me, who's now with Sandler Travis, had a meeting with customs with the GOTS folks to explain their process. And my client still wound up in deemed exclusion. I don't think it ever hurts to reach out to customs to try to work in concert, collaboration, and cooperation with them. And I would say that we have, the agency has a forced labor division in headquarters at the policy level. And obviously, the CEE is more the operations level. So you could either approach the policy people in headquarters. Therese Randazzo is the director of the Forced Labor Division. And we know Eric Batt and James Snyder are the CEE directors and deputy directors. So I think you could start there.
Great, thank you. And our final question of the day, does CBP have certain MIDs that are considered compliant and won't be issued WROs, or is it a process of CBP working through all the MIDs from China?
Well, I think CBP uses, high-risk targeting assessment, working with, in this instance, the State Department, Department of Labor, International Labor Organization, and they're getting information, whether it's on products, whether it's on particular manufacturers, whether it's on particular countries of origin, and they do their assessment that way. And I always say, if your goods haven't been detained or excluded or anything like that, then you have a good mid, okay? But they're not going to, from my discussions with them, say, here's the good guys and here's the bad guys. That we have never done per se, and or they haven't done per se. When I was there, we would publish manufacturers that were a concern, but they're not going to do that in this instance, to my knowledge. I would not expect it.
Great, thank you. That was our final question today. So on that note, we are going to conclude today's webinar. I just want to give a huge thank you to Janet for your wonderful presentation today. We really appreciate it. And to our attendees, as a quick reminder, you will receive a follow-up email containing the slide deck and a recording from today's program. If you have any additional questions, please don't hesitate to reach out. You can always contact USFIA directly by emailing us at info@usfashionindustry.com. Thank you again for joining us, and we look forward to hosting you at the next USFIA event. Have a great afternoon.
Thank you, Shannon. Thank you.
Thank you.